Okay, great, thank you. Our second panel will consider particularly the criminal law and the possibilities, potential, and dangers of neuroscientific analysis. Stephen Morse will be our first speaker. He is the Ferdinand Wakeman Hubbell Professor of Law and Professor of Psychology and Law and Psychiatry at the University of Pennsylvania. Though I hope he doesn't remember it, as I've told many of you, I met Professor Morse a bit over a year ago at a program in Philadelphia and realized that his thinking and scholarship would profoundly impact our law for many years to come. He is, I think, the dominant intellectual presence in law and neuroscience today, and he is skeptical.
Thank you very much. I'd like to thank Pete Alces and the organizers of this conference and William and Mary generally. It's a pleasure to be here. I am skeptical, but I'm also, as you'll hear, cautiously optimistic. What I am here to tell you, though, is that at present, neuroscience is not going to make this a kinder, gentler, greener world. It's not going to transform human consciousness. It's not going to transform the law, at least not anytime soon. Certainly not in my lifetime, and probably not in your lifetime either. For the future, who knows? Here's the warning from The Economist. Genetics may yet threaten privacy, kill autonomy, make society homogeneous, and gut the concept of human nature, but neuroscience could do all those things first. Well, I'm here to tell you it's not going to do any of them. Those wouldn't be good things, and it's not going to do any of them, and genetics hasn't done any of them. You know, we're 11 years into cracking the genome. Hasn't happened. Same kinds of extravagant claims that are now being made for neuroscience were made for genetics and behavioral genetics over a decade ago. It hasn't happened. Now, here's another, wonderful quote. You don't need to read all of it, but let's see if this laser pointer works. All right, what the heck? At some further point, people may grow up completely used to the idea that every decision is a thoroughly mechanical process, the outcome of which is completely determined by the results of prior mechanical processes. That's the reductionist program. You heard it from the Alces. We're nothing but our brains. The law will continue to punish, just read the last sentence now, the law will continue to punish misdeeds as it must for practical reasons. Why? But the idea of distinguishing the truly deeply guilty from those who are merely victims of neuronal circumstances, that's all of us, by the way, so welcome, fellow victims of neuronal circumstances, will we submit seem pointless. That, by the way, is not an argument, it's a sociological prediction. Just please notice that. That stands for what I consider to be the most radical challenge that allegedly neuroscience has produced. Okay. Okay, some preliminary assumptions that I make. I take the law as it is. I'm trying to give the best account I can of what we see. I'm not saying the law is perfect or every doctrine is wonderful. Far from it. I'm a real reformer. But I think the law has a structure and an internal coherence, and that's the kind of account I'm going to try to give to make sense of what we have. I am a non-reductive physicalist monist. By that I mean this. With Pete Alces, I believe it's matter up. There's no top down or anything of the sort. It all begins with matter, but matter produces non-material things like culture. I believe we do have minds that are realized in the brain, but in fact, you cannot reduce mind to brain. I believe that we need a multi-field, multi-level explanation of a phenomenon as complex as human behavior. I borrow this from a philosopher of science and philosopher of neuroscience named Carl Craver at Washington University. The argument is this. If we want to explain why you are in the room today, here's a bit of complex human behavior, all these people sitting in this room today. Well, there's going to be a biological explanation. If your brain is dead, you're not here. Unless maybe you're Jeremy Bentham and someone wheels you in. But is that actually you? And if we're going to give a complete biological explanation, we're going to talk about the intracellular level, we're going to talk about the system level, psychologically. Everything from folk psychological to social psychological variables would be adduced, and sociological. There are sociological reasons why you people are in the room today. Now, Given the phenomenon you're going to try to explain, the level that is going to do the most explanation will vary depending on the context. But here's what I can tell you. If I'm going to ask you to explain why you're here today, no one's going to tell me a story about their brain, including neuroscientists. Yes, your brain has to be intact for you to be here, roughly speaking. But you're going to tell me a story about folk psychology, desires, beliefs, intentions. Roughly, you desire to learn more about this topic. You believe by coming here you would, and you form the intention to be here, and here you are. By the way, Steve Smith, and this is the one thing I disagreed with in his entire talk, I agreed with every other thing he said, when he said folk psychology is a pejorative. It isn't. It's actually a technical term of art in the philosophy of mind and action that uses mental phenomena as a partial explanation of human behavior. And I want to stress partial, because there are also going to be biological, other psychological, and sociological explanations, but mental states are going to be crucial. Okay, what's the law? And the last thing I want to say is I'm with Pete Alces. I don't believe we have contra-causal, metaphysical, libertarian free will. We just don't have it. I think that's preposterous in the current day and age. It may turn out not to be preposterous, but it certainly looks preposterous today. What I do believe we have as human beings is the capacity to be guided by reason, to act in light of our reasons, and as far as I'm concerned, that's all we need for agency and responsibility. I'll come back to that. Okay, what is the laws of implicit psychology and concept of the person? Steve Smith has done this already, so I think I can be really quick. Law is a series of rules and standards that are meant to guide conduct. It shares those characteristics with morality, with custom, with etiquette, with social norms, and the like. It's all ways of living together. And so the question is, what kinds of creatures can be guided by rules? Well, to the best of our knowledge, the only kind of creatures that can be guided by rules that are genuinely reasons responsive are us, human beings. Not the other animals on this planet who share lots of mental characteristics with us, but without the linguistic propositional content that we are capable of, they cannot be guided by rules. Fido doesn't say to himself when thinking, do I urinate on that rug or not? He doesn't say, well, you know, master is really nice to me, or mistress is really nice to me. This is a very valuable rug. There are good reasons not to. But boy, how dare they not get home in time to let me out and stuff. You know, to the best of our knowledge, Fido doesn't do that. We do. Right? We're rule followers, or at least potentially rule followers, in a way that no other creature is. And if you think about that for a second, then you understand what the criteria for responsibility are, or is. It's largely going to be the capacity to be guided by reason. Now, how much reason in what context? That's a normative question about which we can always have arguments. And in light of facts we learn about ourselves, in light of changing social context, those things could change. But in fact, the capacity to be guided by reason is the crucial responsibility factor. Think about the classes of people whom we hold less responsible, or perhaps in some cases not responsible at all. Very young children, people with dementias, some people with severe mental disorder. What they all have in common is, for some reason or another, a diminished capacity to be guided by reason. For kids, it's developmental immaturity. For people with dementias, it has to do with defects in their brains. With people with mental disorder, we don't know yet, but there is a major problem. Okay, so what are neuroscience's alleged two challenges to personhood, agency, and responsibility? The first is the familiar challenge from determinism. Neuroscience has proved determinism is true. If determinism is true, no one can be responsible. Go back to the bull sessions you had in your first year of college. The second is the disappearing person, from the Green Cone quote. We are all just victims of neuronal circumstances. In other words, we're not the kinds of creatures we think we are. Because notice, determinism could be true, and yet we are the sort of creatures we think we are. Creatures that could be guided by reason, etc. Or it could be that determinism is true, and we're not the kinds of creatures we think we are. We're deluded. It's illusory. That's the more radical challenge. I'm going to spend more time with it. Before I get there, however, I thought it's very important to sort of get people to be a little bit less gaga about the neuroscience at present. So let me give you a little bit of background. First, inferences from imaging. We're lawyers, right? Or most of us are lawyers. Here's the question I always ask people who want to use neuroscience. How precisely do neuroscientific findings answer a legal question? You have to translate. Neurons, neural systems, the connectome don't have a sense of past, present, and future. They don't have thoughts of their own. They don't have aspirations. They don't have goals. These are things people do, or people have. So you've got a purely mechanistic system, which neuroscience is, that is being applied to a folk psychological system that's dependent on mental states and actions. You've got to do the translation. So when someone says to me, here's a bit of neuroscientific reasoning or neuroscientific knowledge that applies to law, I say, show me how it actually is legally relevant. How precisely does it answer my legal question? And when people say, well, isn't it good to get under the hood? I hate that analogy. Because you know what? Car engines don't have, as people do, feelings, mental states. They're not rule followers the way we are. Yes, we're products of a deterministic evolutionary process. We are, to some extent, purely mechanical creatures. But we're a very special kind of mechanical creature, and that makes all the difference. All too often, the relevance of neuroscience is rhetorical. See, he's got a hole in his head. He's not responsible. Well, okay, he's got a hole in his head. Why does that make him less responsible? How does that hole in the head show us that he meets our non-responsibility criteria? You know what? If your brain looks really broken, but you're a rational creature, you're a rational creature for the law's purposes. And if your brain looks totally normal, as far as we can tell today, but you are psychotic as could be, you are wildly out of touch with reality, you're out of touch with reality, at least in the context in which your delusions are operative, for example. You are not a rational agent. Actions speak louder than images. The law is concerned with mental states and actions. By the way, I wish I had made that up. I didn't. There was a science writer for Nature who had interviewed me on this topic, and she came up with the title of the article. I love it. Action. Always, if there's a disjunct between what the neuroscience or any psychological test shows and what the behavior shows, you have to believe the behavior. Because the law's criteria are behavior. Now, we've got a malingering problem and stuff like that. Hold malingering aside. Other than malingering, you always have to believe the behavior. The brain looks broken, but the behavior is normal. I'm sorry, the behavior is normal. And for legal purposes, that's a normal person. Okay, I'm going to do this really quickly. Present scientific or conceptual difficulties which may be solved by future advances. Okay? Nothing I'm going to say is a rag on the new neuroscience. What's getting people all excited, obviously, is functional magnetic resonance imaging. That's been the window into it. That only came online in the early 90s, and the magnets have only been available to research centers widely since about the year 2000. So you've got really only 12 years of the technology. It is, despite being a good technology, still a relatively coarse technology. It's very expensive, and it's working on one of the hardest problems there is in science, the brain-mind-action connection. What a surprise that we don't know a lot yet. Well, first, we don't know how the brain enables the mind or how action is possible. Now, I know there are some neuroscientists in the room. I can tell you I have given this talk to countless numbers of neuroscientific groups. No one has contradicted me. No one has contradicted me. We've learned a lot about human capacities we've already developed and what the neural correlates of those are, but how basically this 2.5, because the brain is about the size of 2 average adult fists. How this 2.5-pound chunk of gray and white organic jelly produces consciousness, intentionality, and all the other things we talk about folks psychologically is totally unknown to us. We just don't know. In fact, that's why there hasn't been a major breakthrough in psychopharmacology in about the last 3 to 4 decades, because we don't understand the basic processes nearly enough, which is why all the drug companies now are not developing new drugs. What they're doing is tweaking a molecule of an existing drug to make a new drug for patent purposes. Most of these studies have very small subject size. That's going to get better, and it's already starting to get better. But you see a study there, 9 subjects. Averaging over subjects. When you see that image in the newspaper or magazine. By the way, for those of you who haven't done this work, what you're seeing is not a picture of the brain, and nothing is lighting up. What we know is the brain uses about 20% of all of our energy, despite only being about 2.5 pounds. It's always active all the time, and you're seeing a slight significant uptick in neural activity. And what you're seeing in the newspaper or magazine is you're seeing a transformation through about 5 steps that are way above my pay grade to explain, of mathematical transformations that get you to this very pretty, what looks like a photograph, but is anything but. It's just a visual representation of some basic math. Ecological validity, if we're talking about the law, meaning how realistic is all this stuff? Well, what you've got is people doing stuff in scanners, and it's mostly college students. So now you've got, if the color is one thing and the words say something else, so you've got the word red, and it's in yellow, and you're supposed to say what is the color, not what the word says. People have a hard time not reading. Well, does that predict who's going to mug when it's done by a college student in terms of impulsivity? Response biases and artifacts. Every year, practically, there's a new expose of new artifacts that are discovered in these studies. Not a surprise. Young science. We're just figuring it out methodologically. Again, not a rag on neuroscience. It's just an inevitable outcome. Now, so for example, it was thought that there had been discovered small but significant, not able to use diagnostically, small but significant differences in the structural features of the brains of people with severe mental disorder and not. It turns out that there was a meta-analysis of this last year in the Archives of General Psychiatry, an enormous set of biases in these findings. Not at all sure it's right at present. It is hard as hell to do these studies and control for everything. So that's just a major problem. Lack of replications. You know, you don't make your chops as a scientist by replicating what the other guy did. You made your chops by doing something new. So what you don't have is a whole lot of replication. So you got a lot of discrete studies with small numbers of subjects, et cetera, et cetera. What we know today is correlation and coarse, not causation and fine-grained. We know neural correlates. We don't know neural causes. Every time you read a neuroscience study that says something like this part of the brain modulated or did this, suggesting causal knowledge, it's hand-waving. There isn't causal knowledge. Virtually never in these studies. Moreover, notice the implicit dualism. You've got this little homunculus in your brain that's doing this and doing that. That's the language of agency. Brain regions aren't agents. They're mechanistic systems. You know, I ask a lot of neuroscientists, how come you put in all this language when you know you can't cash out that claim? And what do they say? That's how you get your papers published. Neuroscientists don't go on fishing expeditions. They've already identified something well characterized they want to understand the neural correlates of. For example, people with schizophrenia, people without. Identified today, still, there are no neural correlates for schizophrenia that can be used diagnostically. It's got to be done behaviorally. Okay, we got people who clearly have schizophrenia, evaluated behaviorally, and people who don't. And now we find a difference between the two. Statistically significant structural or physiological difference. Okay, notice you've got the clearest conceivable cut to begin with, and yet you're still going to have overlapping curves. You've got a small statistically significant difference, but most people in the two categories that are clear-cut still look alike. Where do we need help, we in the law? In those gray area cases. And that's where the neuroscience can help us least, because that's where the overlap is nearly perfect. I'm going to skip over countermeasures. So we're going to run out of time. The challenge for determinism. Agency, but no responsibility. All right? First, determinism is not fatalism. Determinism says we got causal closure in the world, and roughly every event follows lawfully from preceding events operated on by the causal laws of the universe. Even if that is true, your deliberations can make a difference. Here's an example from Daniel Dennett. You're standing on the edge of your apartment building on the roof, and you're deciding whether to jump or not. I feel like crap. It's never going to get any better. I want to die. On the other hand, my family's going to be impoverished. Everyone's going to be sorry. Do I jump or don't I jump? And you finally decide. Now on the way down, you say something. No, that wasn't a very good idea. There your deliberation is going to make no difference. That's fatalism. Notice both are fully consistent with the truth of determinism. Everything's determined, including your deliberations, arguably. All right, this is a familiar challenge, as I've said. Metaphysical libertarianism, I've already taken off the table. You want to argue about it, you can, but don't talk about quantum mechanics in the brain. It's not going to get you where you want to go. So the real debate is between the hard determinists, those who believe if determinism is true, no one can be responsible, and compatibilists who believe that determinism can be true and people can be responsible. Now, the major challenge, and I feel the tug of it, is hard determinism. Many people don't feel the tug of it. I do. Basically, it's the principle of alternative possibilities. If only one choice was real, even if you did deliberate, you did exert agency, but only one choice was really possible, and there was no real alternative possibility, how can anybody be responsible? Well, how to cash out the principle of alternative possibilities is a really sophisticated problem in modal logic. And here's what I think I'm here to tell you. The logicians can't solve it, and the law and responsibility and our sense of ourselves and everything else is not going to turn on really sophisticated notions of modal logic. I just think that is highly unlikely. So here's what is true. What we know is some movements of the body, like spasms, are not actions. Doing something that might resemble a spasm intentionally to make a point is an action. That is a truth. Some people have the mental state required by the definition of the crime. Some people don't. That is a truth. Some people who commit crimes are legally insane when they do it, and other people don't. That is true. Some people act under duress, and some people don't. That is simply true. Notice those distinctions track both deontic and consequential theories of just punishment that we have reason to endorse, and notice that they are completely consistent with the truth of determinism. That's just the way the world has been determined to be, just as I described it. So what I'm suggesting is, if you're a compatibilist, someone who believes even if determinism is true, if we are the kinds of creatures who can be guided by reason and for whom our reasons make a difference, that's good enough for responsibility. I don't need to have the godlike power of acting uncaused by anything other than myself. Many law professors believe they have that godlike power, but they're wrong. Okay. The rubber hits the road. Okay. Why can't compatibilism save agency? What I said earlier on. Two possibilities exist if determinism is true. One, we are determined to be the kinds of creatures we take us to be that were so well described by Steve Smith. Creatures who act for reasons, who have a rich mental life where that mental life makes a difference, etc., etc. The other possibility is we're deluded. Our mental states exist. Virtually no one claims we don't have mental states anymore, but they're epiphenomenal. They do, that's just a fancy philosophical word, meaning they don't do any work. They don't do anything. It's just mechanistic causation all the way down, not turtles all the way down, mechanistic causation all the way down, and mental states have no independent causal power, contra to agency. Okay, what's the evidence for it? The brief conclusion is there's not a shred of evidence for it today, and it's very likely to be wrong for reasons I'm going to get to. Let me just go through some of the indirect scientific evidence. We're unaware of the causes of our behavior. Well, sure. Who could ever be aware of all of the causes of your behavior? Suppose you're completely mistaken about why you're doing what you're doing. I mean to kill that guy because I think he's dissed me. But what I really think I'm doing is killing my father, with whom I'm in Oedipal conflict. But I just have no idea about it. That's all make-believe, but let's go with it. So I have no idea why I'm really trying to kill this guy. So what? Do I know I'm trying to kill him? Do I try to kill him intentionally? Do I know that's against the rules? Of course. That doesn't prove we're not agents. It just proves agency can exist even though you're not aware of all the causes of why you act as you do. Automaticity. If you notice, I'm slightly pacing as I do. I can assure you I'm not thinking about this. Lots of our behavior is automatic. Thank God. Imagine if you had to think about every single thing you did, the good reasons for and against. How many of you, don't raise your hand unless you can do it without thinking, can tell me which leg you put through your undershorts first? One person in the room. Okay? Typical. The most automatic thing you can think of. You've been doing it the same since you were first learned to dress yourself. Why would you ever think about it? But suppose I said to Professor Ward tomorrow morning, with a gun at her head, you put that leg through first, and I'm going to kill you. All of a sudden, she could bring that totally automatic bit of behavior under the control of reason, if she had reason to, right? Lots of stuff is automatic, and with various kinds of brain disorders, there can be automatic behavior. That's not the basic case. What reason is there to think everything is automatic, right? Deception about agency. Very clever laboratory work, really good laboratory work, has shown you can fool people about whether they're actually causing movements that go on. Okay, clever work. We can be fooled about whether we're agents. Is that sort of deception likely to be the default in nature? I don't think so. What you can do with a couple of undergraduates in a laboratory doesn't seem to me to be the default in nature. There's localization of brain activity. Duh. Well, first of all, we're not sure about that for the most part. When you see something activate, and we think, that's the portion of the brain that is being activated in association with it, we don't know that other things aren't as well, but some localization seems relatively assured. We have lots of information about that from lesion studies, but so what? I mean, again, your brain is dead, you're dead. Whatever bit of behavior you're doing, there's going to be a partial brain explanation, so what? All right. Libet and the post-Libetians. This was an industry. 5 minutes. Great. This was an industry. It's no longer an industry. So here's the setup. You tell a subject, I want you to raise your hand whenever you feel, raise one finger whenever you feel like it. And they got a clock. So you can report when they are aware of first having done that. There's no reason you should do it, just whenever you want to at random. So it turns out, because you've got a clock, that you get activity in the supplemental motor area, which is really not well understood as a neural region, about 550 milliseconds before the person actually raises the finger. They become aware of their intention to raise the finger about 100 milliseconds, give or take, to 150 milliseconds before they actually raise their finger. My brain made me do it. That's the argument. It's just the brain. And everything else, the intentionality made up afterwards, that's just a story. My brain makes up, notice the dualism, brain is a little homunculism, my brain makes up to convince me of what I've already done. What's the reasons to reject the victims of neuronal circumstances? Well, let's start, just to begin with, that the reductionistic program that it supposedly instantiates is completely uncashed out at present. Intertheoretic reduction is so hard, we can't do supposedly the easiest reduction, chemistry to physics. Can't do it. The notion that we now can confidently say we're going to be able to reduce mind to brain, one-to-one, token to token, is just, at present, preposterous. Problems of the Libet paradigm, neuroarrogance. We don't know how the brain, mind, action connection works. There's no evidence that intentions play no role. Maybe it's crucial. By the way, the most current sophisticated thinking about Libet is what you're getting is neural evidence of a predisposition. You're not getting the brain doing it. No evidence that intentions play no role. In fact, there's lots of scientific evidence that intentions do play a role in our behavior. Also, it's a trivial task. Is that going to explain why you're sitting here today? Maybe, maybe not. Another reason, in addition to problems with Libet, common sense. What would it take for you to give up your picture of yourself? How much would you have to believe? Notice, what would I have to believe? Steve Smith adverted to this. It's sort of internally incoherent. I believe that my beliefs make no difference, and therefore I believe you should believe something different.
Scientific evidence for the efficacy of intentions, I've already talked about that. The proto-theory of mind has been around in our species and in earlier species, first identified experimentally in New World monkeys 40 million years cut off from us in the evolutionary tree. Is it possible that evolution can serve this theory of mind for 40 million years when it's doing nothing? Possibly. Pretty expensive. Doesn't mean it isn't. If you don't have a good theory of mind, let's say you suffer from autism spectrum disorders, you really are going to be a defective human agent in terms of your ability to behave adaptively and successfully. Minds matter. Finally, normatively inert. Vice Provost Hansen referred to this. If it's just mechanistic processes, I've got one more minute. If it's mechanistic processes only, and our minds are really doing no work, our reasons don't matter, what reason do we have to do anything? What normative conclusions would possibly follow? If it's just mechanistic, then reasons don't matter, and normativity goes out the window. Okay, I'm going to skip over. I am actually cautiously optimistic. I think neuroscience is going to be able to do modest incremental things over the next, well, not in the next 10 years, but maybe in the next 30. But it's not going to do anything transformative. I wish I had time to talk about Mr. Oft. You know, there's a hole in your head. We are acting agents, not Pinocchios. And our brains are not Geppettos pulling the strings. My view is this. The task of neuroscience is not reductively to explain away agency. The task of neuroscience is to explain it. Agency, I think, is secure for now, and I also believe for the foreseeable future. Thanks.
Our final speaker is my colleague on the William Mary Law faculty, Professor Cynthia Ward. And she is not, to damn her with faint praise, she is, not to damn her with faint praise, one of the smartest law professors I have ever met, and probably the most graceful legal writer. I had the privilege some time ago to co-author an article with Professor Ward, and still I'm often asked about it. Invariably, the person who asks goes on to commend half of the article. The half that Cynthia Ward wrote. Sweet. I introduce my good friend and colleague, Cynthia Ward.
Thanks. One of the many things that makes Pete such a wonderful colleague is that we both care very much about a whole range of subjects, and we often disagree about what is right and wrong in those subjects. So that is a wonderful thing to have at your beck and call on a faculty. Ooh. There we go. Okay, so I'm not going to talk about the nature of moral agency or human agency. My concern is less focused on that than on the conversation about that and about other concerns important to the criminal law between the law and psychology as a field. And in particular, what has caught my eye over the last few years as I've done a more in-depth study of psychology and thought more about specifically that conversation between psychology and criminal law, is the criminal law's tendency to give a warm embrace to psychological findings which come attired in scientific garb, accompanied by regression analyses, charts, graphs, and so forth. We find these very bewitching just by themselves. And in the case of neuroscience, of course, these this fascination with numbers and graphs and so forth is accompanied by almost a spell cast by fMRI and other imaging techniques, which seem to show us the brain actually doing things and thinking things. Now, of course, as everyone else has said, all these technologies are very exciting on their own turf and medically speaking offer wonderful opportunities for helping cure disease and so forth. But I think the criminal law's enthusiasm is about more than that. The intensity and the fervor, the sheer relief which greets each successive wave of psychology as science, the relief among criminal lawyers, and is worthy of its own discussion, and I'd like at least to suggest some points of discussion. And that enthusiasm has been humorously, but also aptly described by Professor Morse, who talked of it once as brain overfilling syndrome, right, in the context of neuroscience. So the idea that neuroimaging, for some of the reasons that he discussed, proves certain things about criminal responsibility, and that idea is out there in spades. This is only this month's ABA journal talking about the movement of neuroscience into the courts, and I'll talk more about some of the findings of neuroscience and how they've crept into the criminal courts. But some of the claims made for the possibilities of these exciting new technologies, specifically in the field of criminal law, are just breathtaking. And that's what concerns me. Claims that neuroscience and neuroimaging are going to solve these problems that have haunted the criminal law for a long time, are received by us, by lawyers who pride ourselves on our analytical thinking and teach our students to do that as a matter of course, with a degree of enthusiasm and lack of skepticism that I think can be quite worrisome and has been in the past. And the other piece of this is that this has happened periodically over the last 150 years. The criminal law and other areas of law fall in love with scientific psychology and embrace, and I'll talk more about this in a few minutes, embrace its findings in a way that seems radically unreflective. So why do we do this is my question. Why is it so hard for us to apply what is really our trademark analytical thinking and skepticism to, why are we not more protective of the very grave decisions that the criminal justice system has to make? And I'm not sure that I have any final answers, but I do think part of the answer may be that with all their separate excellent achievements in their separate spheres, that law and the field of psychology also have reciprocal vulnerabilities, and that it's those vulnerabilities which largely attract them to each other. And that strikes me as worrisome. And my comments on psychology are done as an outsider, someone who's very interested in the subject but is not a trained psychologist, more of a de Tocqueville approach to comments on that subject. My comments about the criminal law come from having taught and loved the subject for a long time. And one thing, as a recent student of psychology, that struck me immediately is how very focused psychology is as a field on being taken seriously as a science. Right? And this is not an obvious thing, right? From the time that psychiatry and psychology inaugurated, Pinel freed the inmates of the asylum at the Salpêtrière in Paris. Samuel Tuke and his Quaker Fellows started the York Retreat at the turn of the 19th century in England. Psychology has had as many possible roots in philosophy, in just the theory of just compassion and human kindness, in other fields, and yet periodically this, and I'll talk more about it in a minute, this focus on must be a science, must be taken seriously as a science comes to the fore. And I think, to me, it's worrisome from the perspective of a lawyer because at some level what it tends to mean is that that intuitions undefended by a regression analysis are somehow less worthy, right? And that puts a lot of pressure to make those regression analyses more exact than they possibly can be. On the criminal law side, I think there's a fear and an anxiety. We're afraid of our job, in a way. We have to decide questions like someone's blameworthiness and responsibility, and almost pretend to know things about human beings and about what they do that we can't, in a satisfying way anyway, an emotionally satisfying way, we can't really know. So we can't know, but we must know, because we make these decisions about people's liberty and even life that suggest that kind of knowledge and suggest the need for it and suggest our duty to have it. And so numbers, charts, graphs, and machines, which tell us that we do know, or that we can know, indisputably and by findings of analysis and scientific studies, come as a huge relief. So there are these reciprocal vulnerabilities around science on both sides. And in my and I think there's a way in which you can talk about the relationship between fields and analogously to the way you talk about relationships between people, right? So in my more irreverent moments, what comes into my head is a scene from the movie Sleepless in Seattle, where Annie Reed goes to her brother Dennis, who's a psychologist at Johns Hopkins, and asks him about the nature of true love, right? Is there such a thing as true love? And his reply is as follows, right? And I think, well, the reason that comes into my head anyway is that is this vulnerability idea. I think that there's something worrisome about the attraction of psychology to criminal law and vice versa, in that much of its energy comes from flaws in its knowledge and approach. And what I want to talk about is a few examples in the past where the criminal law has become enamored of scientific psychology and scientific dress. And then I want to come back to a recent example, worrisome example of the application of analysis of the neuroscientific perspective. So, but let me say two things first. These are embarrassingly brief historical examples just because of time. But one problem I often have when I'm using history in class with my students is that there's an immediate, when I start talking about historical examples, there's an immediate attempt to distance oneself by saying, well, okay, we can see that that was bad 100 years ago, but that was before. That was before we knew. Before we knew what, of course, is the question. And I'd like to ask everyone here to sort of suspend that almost automatic thought, right? Because what I'm going to try to do is draw some parallels between the criminal law's embrace of prior eras in scientific psychology and what's going on now. And secondly, I want to avoid, and I want you to avoid making any cheat points here. Some of the examples I'm going to use are well-known and are shocking from our point of view. I believe, with historians, that the challenge of history is to put oneself in the place of the people who were there when the events were going on. And from that perspective, many of these things that I'm going to talk about, which seem to shock us now, make a lot more sense. So I want to say that. But the first example that I want to use has to do with with neurology and science generally, psychological science generally, in the late 19th century. So there had been almost a century of moral treatment, kindness, and respect-based approach that didn't necessarily require a lot of medical science. Many asylum superintendents were not doctors, for example. And there have been some depressing results from that. Overcrowded asylums, lack of treatments for folks, and into that mood came the neurologists and argued that the study that even if mental illness couldn't be cured, right, which was the sort of a dominant impression at the time, that it could be studied as a science. And neurologists moved into take over asylums, and an era of studying patients and including their brains was inaugurated. A statement by one of the primary neuropathologists in Europe at the time, Dr. Meinert. Again, this idea that psychiatry can finally establish itself as a science. The second piece of this arose at the same time from evolutionary theory, from Darwin. And the idea was that of course, that evolution, a man had evolved from beasts. And what many psychological commentators focused on was looking backward at that if man evolved from beasts, they started to theorize, then we could return to our bestial nature. Our bestial nature is still there, and there's a danger that we could return to that. So from evolution, maybe a sort of hopeful view, the psychology turned and psychiatry turned to focus on devolution or degeneration is another way in which it was discussed. So degeneration and degenerists putting forward the idea that there were groups of human beings that represented prior primitive forms of human development, right? So they moved from the theory of evolution and degeneration and turned to social problems and to use the degenerationist theory to diagnose social problems of poverty. There were problems of criminality, which I'll talk more about in a minute, and so forth. And various groups were, the perceived inferiority of various groups were seen to be atavistic, throwback characteristics of primitive times, sort of prior generations or prior iterations of human beings. So, and various, as I say, the degeneration is focused on various groups of folks, including musicians and artists on the one hand, whose work they saw as threatening. There was anti-Semitic division, anti-Semitic area to it also, and women who were otherwise seen as inferior. This is one of my favorite ones from Dr. James Reed, who was a attendant physician to Queen Victoria, discussing puerperal insanity, which was a strange malady that afflicted women during labor and childbirth, and describing that in kind of during this era, right? And more specifically, in the criminal law, Cesare Lombroso, an Italian, the father of criminology, an Italian criminologist and physician, began using these ideas, these degenerationist ideas, the idea to craft a theory that there was such a thing as a born criminal, right? And in doing that, he interviewed many criminals in prison and focused very specifically on their physical features, and graphed them and presented this as science, and there was a debate about it, but it was taken quite seriously. So things like, one major focus was the shape of a person's face, sloping forehead, but even more than that, and Lombroso assembled all this into tables and charts, where he thought he could, to the point where he thought he could diagnose criminals, and there was an intense focus on the face, as I said, on eyes and ears and the shape of the nose and so forth. And there was some debate both in Europe and in the United States over this, but it was taken quite seriously in the mainstream, not only by psychologists and psychiatrists, but by the law. And just one example of this is in probably one of the most celebrated criminal trials of the era, the trial of Charles Guiteau for killing our 20th president, James Garfield. Dr. Edward Charles Spitzka, a prominent neurologist, testified that Guiteau's criminality was a result of congenital malformation of the brain, and spoke of this kind of Lombrosian type, in this kind of Lombrosian type vocabulary, right? And so again, first example, the law and the criminal law adopting this sort of language, this incarnation of scientific psychology as the basis for legal testimony. Coming around to the change to the 20th century, the idea that of degeneration, that there were groups that were throwbacks and atavistic and weak-minded, progressed to the point where such folks were thought of as dangers to society. And Henry Goddard, a prominent psychologist in the United States, participated in this debate in which mental deficiency was categorized. Again, this was cutting-edge science at the time, into various categories, including feeble-minded. And what that led to was, speaking of a legal impact, was a number of statutes in many states to provide for compulsory sterilization of feeble-minded people who were in institutions. And ultimately to Buck against Bell, a case involving 17-year-old Carrie Buck, who was put into a home for the feeble-minded after becoming pregnant following being raped by her foster family's son. And the institution, under the Virginia's law, requested a compulsory sterilization, and of course it came up to the Supreme Court, where this is famous language here, but what I want us to think about right now is how directly it comes from psychology and psychiatry at the time, and from the degenerationist ideas that were so much a part of it. The threat to society from feeble-minded folks, the idea that they are degenerate, and manifestly unfit, and that imbecility, as it was called, is inherited and passed down, from generation to generation, and thus that folks who were deemed to be that should not be able to reproduce. The power of this and its significance was great. Buck against Bell provided justification for the majority of states to adopt sterilization laws, and those laws linger in many jurisdictions for decades. My third example is the example of leucotomy and lobotomy. Again, this sort of interaction between the law and scientific psychology. So Egas Moniz in Portugal developed a procedure called a leucotomy that involved drilling in the brain and cutting off nerve fibers between the frontal cortex and the thalamus. And in 1949 won the Nobel Prize for that. And the procedure in the 1930s was picked up and then changed into ultimately what we know as the transorbital lobotomy by Walter Freeman, who went around the country eventually doing this procedure. And I love this picture. This is from a story from the Saturday Evening Post in 1941, conveying how seriously and how scientific the procedure of lobotomy was seen. Again, no cheap points here. There were no other treatments available for folks, and the desperation of psychiatry to have some treatment that worked is worth noting. But the way in which lobotomy was seen and depicted, this is a major media or outlet, but is reflected in some of the legal reactions, which I'll talk about in a minute. Again, the energy with which the procedure is received, and the way in which it's depicted as very scientific. A world that once seemed for these patients the abode of misery, cruelty, and hate is now radiant with sunshine and kindness to them. The lobotomy generated a lot of research in the criminal law as to its potential in curing criminal tendencies. So I just to pick one case that I've studied recently, of a man who was arrested for a number of burglaries and was facing 40 years to life in prison, and offered to the court to have a lobotomy to cure his criminal tendencies, and that would alleviate some or all of his prison sentence. He had the lobotomy. Ultimately, he got a lower sentence. But it's just symptomatic of the law's reaction at the time and the vigorous exploration within the criminal law of whether lobotomy and the acceptance by many of whether lobotomy could cure criminal tendencies. So now back to our current day and the promise of fMRI and so forth. We've learned a lot in terms of information, but the law doesn't seem to learn that perhaps Pete was saying earlier that maybe we should mistrust our intuitions in the presence of science. I would reverse that. I think the criminal law always has a choice here, right? A choice to rely on the methods of decision which are intuitionistic, but hopefully analyzed intuitions that we've always relied on, or to embrace science. And we seem too quick to do the latter. Again, the rise of neuroscience and the findings and cases, the findings of evidence, neuroscientific evidence being introduced into criminal cases is notable, is really stunning if you think about how quickly it's happened and how thoroughly it's spreading. So in 2008, and what I want to do is raise a similar concern with respect to something that's recently happened in reaction to fMRI studies in so-called social neuroscience. So social neuroscience being, in the context that I'm talking about, the piece of neuroscientific research that uses fMRI to measure brain activity on the one hand and individual personality traits and character traits and social behaviors on the other hand, right? So empathy, experience of rejection, things like that. Things that go right to the nature of person, or supposedly go right to the nature of personality and character. And Ed Wool, the author of this paper of voodoo correlations, he subsequently changed the title at the request of his publisher, but this was the original title, thought that some of the correlations being shown by in studies between fMRI, brain activity as measured by fMRI, and personality traits were just much too high. They overrepresented the correlations, and he and his colleagues went in to the details in some of these studies to kind of ask why. Why is that? And they noticed that they began to discover that those very high correlations involved a kind of selection bias by the researchers. And these are studies that are appearing in the top science journals, right? So, and done by top researchers at top institutions. So there's a kind of selection bias that appeared in more than half of these studies that involved selecting for purposes of measuring correlation a subset of voxels. So voxels are like 3D pictures of the brain, similar to this. So selecting a subset of voxels whose activity during the scan was above a certain preset statistical threshold, and then using this biased data as the basis for computing average correlations across subjects, right? So, and the result was that the correlations between the brain activity as measured by the MRI and the personality trait or behavior being measured were dramatically overstated. And now this caused a huge furor in the field of social neuroscience. But a year later, a study done at the National Institute of Mental Health confirmed the finding that something like half of the statistical studies based on fMRI were substantially, significantly overstating the correlation between brain scan measurements and personality traits and so forth. So, why does this matter? I think it matters a lot in the context of criminal law. One thing that I hope the example of Wool and voodoo correlations brings up is that we somehow haven't learned to step back and to think in a kind of classically lawyerly way, analytically, about these technologies and about psychology as science. And about certain other things, like psychology has a different point from the law, right? Psychology is about finding treatments. The law is about assigning responsibility. Those are different projects, and we tend not to notice that. Science, as I said, casts a spell in both fields for reasons that make historical sense in each one, but often are not a great combination. Vulnerability, tugging vulnerability. Great excitement over new ideas and theories and treatments is natural, but again, the law needs to stand back and be skeptical. And because it's tough to assign blame, and because we really know that we don't know what we wish we knew about responsibility and so forth, we tend to experience science and new developments as more promising than they are. And I want to close by making a point that might seem counterintuitive. We treat science with an authority, as Pete said, that makes us feel better about anxiety-causing event or the anxiety-causing job that we have. And we treat it as leading us to the truth, and we treat it as something that can help us reach the truth. But there's a sense in which I think that the reality is the opposite of that. That we seek the truth, and we seek certainty through developments in science, giving a new meaning to the phrase, really, safety in numbers. Right? We find safety in numbers. And I think that vulnerability in the law ought to lead us to treat scientific authority with more rather than less skepticism than we treat other sources of information and authority. So, thanks.
My conclusions differ. The reason that we had this panel focusing on the criminal law and neuroscience is because most of the cases and commentaries concerning the significance of neuroscientific insights to the law have been criminal law cases. That just seems where all the foundation, that's where all the money is. There is so much at stake also in the criminal law, and we are all party to it, even if we are not defendants. It is we who charge the accused, we who trust and serve on juries, and we who sentence the convicted and bear the costs of their incarceration. We are very much involved in the criminal law. Each of those actions has normative dimensions and assumes a particular conception, I believe, of the human agent as object of the criminal law and as administrator and supporter of it. It is also true that no area of the law is so obviously concerned with the nature of human agency as is the criminal law, both with regard to imposing punishment, what kind, how severe, and with regard to our confidence in the conclusions we reach. Morality seems to matter more so far as the criminal law is concerned, primarily because the consequences of a finding of criminal liability are so great. Also, it is often the least powerful among us who become the subject of the criminal law, and a measure of a society, of a civilization, may be how it treats the weak and the vulnerable. Now, in all candor, my observations this morning are not about the criminal law and neuroscience, are not obscured by any real understanding of the criminal law, though I have seen every episode of Law and Order at least twice, and I have begun my study of CSI, but only the original CSI. I'm not branching out yet. Okay? It does seem to me that neuroscience's impact on the criminal law is perhaps uniquely limited by deontic doctrine, deontic vocabulary, and that may even obscure what neuroscience could offer. Criminal law, through its reliance on folk psychological conceptions, depends on the dualism that an empirical morality informed by neuroscience would undermine. As I heard Professor Morse say once, whether the defendant is responsible and what we'll do with him are two different questions, at least separable. Neuroscience, I think, may provide the means to separate those two questions and inform their resolution, ultimately. By and large, I agree with Professors Morse and Ward. To date, the reach of neuroscience exceeds its grasp. At least so far as the criminal law is concerned, there is good reason to be cautious, if not downright skeptical. And it is both accurate and not surprising that the criminal law, as currently conceived, does not need neuroscience. So I agree completely with Professor Morse on this. But the reason is that criminal doctrine is largely written as though the empirical insights of neuroscience were not available, much less normatively pertinent. It is somewhat like trying to apply the rules of football to a game of chess. The fit is wrong. It would be wrong to conclude that there was error in the effort to understand chess. Science, though, I think has served the criminal law well, and this is where, this is a historical matter I might disagree with Professor Ward. Consider DNA. We couldn't imagine DNA 50 years ago, I don't think, at least not operating in the criminal setting. But how many have been exonerated who were convicted based on so-called reliable evidence, on intuitions, on juries' efforts to determine veracity by reference to the demeanor of the defendant? Doesn't work. We ultimately find many of those convictions to be erroneous. Science has caused us to reconsider eyewitness testimony and confessions, even when there is no DNA evidence available. As it turns out, neuroscience has taught us, science is not believing, even before it is confounded by remembering. And innocent people, as we know, confess all the time. The way the criminal law deals with juvenile offenders reveals a fundamental tension. Be more forgiving of the young, if that's the right word, more indulgent perhaps, but not of those who have reached a certain age and whose indiscretions are identical to those of the young, and perhaps identical because their cause is identical. In a recent opinion, this very year I believe, Judge Richard Posner observed, "The court has learned from brain science that teenagers are immature." Exclamation point. But we knew that. The problem with using it as a basis for distinguishing between murderers of different ages is that many adult murderers have problems with their brains too. Why is it not cruel and unusual to sentence them to life in prison? Surely the judge's irony was intentional. Note, though, how neuroscience reveals what is a dichotomy in the eyes of the law, according to the terms of legal doctrine, is instead a continuum. For the very reasons that we would recalibrate deterrent and retributivist goals to reflect the circumstances of youth, defined perhaps as an incompletely developed frontal lobe, we need to be considerate of the same circumstances in a criminal defendant who may have reached the age of majority. We determine youth by reference to chronological age because age is an accessible heuristic, but it may mislead, as my colleague Vivian Hamilton has explained in some of her work. Thanks to neuroscience, we can better understand the impact of emotion on both perceptions and judgment that matter to the criminal law. The self-defense defense, much in the news lately, seems like a candidate for better understanding. What is unique about such bases of exculpability? Everything or nothing, or something in between? Criminal law is based on responsibility, culpability, blame, retribution, deterrence, which I believe in some cases represent a misconception of the reality of intuitivist vocabulary. The terms of criminal doctrine are deontic, insofar as we care about retribution, or can only explain some aspects of punishment in non-consequentialist terms. For example, why do we care about distinguishing crimes committed in the heat of passion, but not care what the physical components of that mental state are? We are surprised that restorative justice works in the circumstances in which it does, because we have trouble understanding or taking seriously the nature of human agency and empirical morality, considerate of neuroscientific insights might reveal. So criminal doctrine is subject to the same critique as any body of legal doctrine that indulges an inauthentic conception of human agency. There's just often much more at stake, and we, the people, are all party to it. If deontic conceptions lack a reality referent, and retribution is a deontic concept, then retribution, even if accurately calibrated, could have no good effect. Retribution may in fact be immoral, as inconsistent with human thriving, perhaps, if you agree that that is a plausible construction of morality's object. More on that below. Now, retribution might feel good, but from a consequentialist perspective, that feeling would have to be a greater good, a greater contributor to human thriving than the negative externalities retribution creates. The extent of retribution's benefits is psychological, and the measurement of those benefits would, perhaps, be an empirical matter. How much better does it make you feel because of the release of oxytocin once more, perhaps, to incarcerate the juvenile offender for 25 years. Against that psychic benefit would have to be measured the cost to all of us, not just the offender, of that glow that retribution gives you. The cost of the public treasury of keeping someone locked up for 25 years, as 3 strikes laws might well do, as well as the negative psychic costs associated with doing so. Of course, what gives you the glow may be repulsive to others, and their despair has to be balanced against your glow. Also, we need to know the characteristics of the subject of punishment that are pertinent to a retribution calculus. And even if we know what they are, how do we calibrate the punishment to even roughly vindicate them? This is part of the challenge Professor Adam Kolber's argument presents. Same problem, of course, would pertain with regard to deterrence. Isn't control pertinent, determinative, even if all the criminal law doctrine requires is appreciation of right and wrong? And what are the constituents of control? Might not neuroscience reveal them? The criminal law doctrine, then, could be appraised in light of its ability to affect human thriving. Do terms such as blame, fault, responsibility operate in such a way as to promote defensible, morally defensible objects of the criminal law, consequentialist objects stripped of their retributist decoration. But to make or even approach that determination, we need to more accurately formulate human thriving. What, after all, is the object of it all? More happiness? How would we measure that? Patricia Churchland suggested it all does come down to oxytocin, and I realize that's an oversimplification, but a pretty good one. Douglas Adams said the answer is all 42. That's all we need to know. Neuroscience may not certainly provide the answer to that important question, but by focusing on accessible consequentialist concerns, it may enable us to eliminate some of the false answers. That, at least, is Sam Harris's suggestion. There is, though, another side of the equation, where the empirical challenge really emerges. Is there not a risk that we will trust the science too much too soon? I believe this is, of course, the concern of Professors Morse and Ward, as well as many others. And here is there's a fear that we might use this modern phrenology to limit the freedom of those whose actions have not yet demonstrated the propensity to harm the interests of others. Recall Minority Report, the science fiction movie starring noted Scientologist Tom Cruise. Yet we do right now quarantine those with tuberculosis on consequentialist bases. And there is good reason, and there's no good reason not to do so. We might think of criminal propensity, if certainly established, as indistinguishable from a certainly accurate tuberculosis diagnosis. And establishing it certainly is an empirical, not, I think, a conceptual matter. Epileptics who need medication to drive will today be culpable if they drive without that medication and hurt someone. Sexual predators have to report to their local police precinct on Halloween, but they're not formally incarcerated. So we have demonstrated, calibrate our response to allow for our uncertainty. The science can help long before it is perfect. After all, 1% of the population is schizophrenic, but not all of them present a real and present danger to themselves or others. But that, too, is an empirical problem. Now, one response to the challenge based on the Minority Report fear is that the criminal law right now incarcerates many, many offenders who present no future risk of harm to themselves or others for the sake of poorly calibrated deterrence goals, or perhaps in the interest of retribution, which, recall, lacks a reality referent, independent of maybe measurable psychological effects. Well, science, DNA testing has revealed that. The many hundreds, even thousands, who have been wrongly convicted on the basis of eyewitness testimony and convictions. But two wrongs do not make a right. The argument for neuroscience cannot be that it is no worse than the status quo. We are not yet, I agree, at a place where we can look at an fMRI scan and predict with any confidence certain criminal propensity, or, for that matter, even use fMRI scans to reliably determine veracity. But is that an empirical challenge or something more? We err when we confound the empirical and the conceptual. We may not know just precisely when the tumor took over Mr. Oft, but we know that it did, and that's a start. I agree completely with those who identified the empirical challenges, and I share their impatience with those who would claim too much for the science. Yet, there is certainly too much snake oil. comes to mind is no-lie fMRI is one. But neuroscientific insights are revealing to us the mechanical nature of human agency, and even why that nature is so unsettling to what is very human in us. There are consequences to that revelation that we are mechanical, beyond the free will determinism tension. Responsibility in such a world may be a conclusion, a label masquerading as a calculus. There is an acknowledgement that, in the course of human affairs and law's regulation of them, through doctrine, there may be much less than meets the eye. By which I mean we are not magnificent but inscrutable after all. We are often confused and can't even multitask very well, which is why I do not permit laptops in my classes. Our competence is overrated. Perceptions, even intellectual constructs of humanness, may be deceiving. Many illusions, though, are quite useful, but we can improve beyond them when we appreciate their illusory nature. Consider Dr. Ramachandran's work on phantom limbs, understanding and then using our brain's ability to deceive itself for good benefit. Most crucially, neuroscience challenges our understanding of what morality is, and indeed whether morality, as we currently conceive it, is. Not just as dictates, and insofar as the criminal law would, indeed must, instantiate morality, criminal law doctrine cannot be inconsiderate of our new, empirically informed conception of morality. And empirical morality may look nothing like what a deontic morality would seem to be. Morality, after all, may not be a natural kind. That is, it may depend on us and not be independent of us. Indeed, a great deal may be revealed to us and about us when we explain or just better appreciate the mystery that is consciousness. At times, I think that's the source of all of our disagreement on these matters. It may be that only when we get a better grasp of that phenomenon, consciousness, will we be in the position to understand the empirical source of ostensibly non-empirical sensations. Just as free will is a useful illusion, the dualism of deontology may be useful, or at least similarly comfortable, though it could be that we need to be uncomfortable in order to discover greater truths. Perhaps we do not have to wait to solve consciousness, though. We may only need to acknowledge that its mystery is a source of normative illusions and ultimately unhelpful delusions, which neuroscientific insights can eventually overcome. We do have a few minutes for questions, and we'll try to do the same form we did last time. Yes, ma'am.
My question is more. I'm familiar with all of your examples. I'm a psychologist and a neuroscientist and a arts and sciences. And I agree with Professor Alces that we become more responsible for dealing with criminal law. I would offer that psychology, our vulnerabilities, and we have them, is not
Well, let me repeat the question. I agree with Dr. Alces. And then the subordinate part of the question was, how do we distinguish the good from the bad science, and perhaps wouldn't you acknowledge that we should take account of the good science as well? Is that a sufficient recapitulation?
And that being a scientist is not a particular vulnerability.
Okay.
Sure. Well, and I think, as I may have said, I think that there's a natural reaction to say, when one uses historical examples at all, well, that's not real science, right? That's not good science. But I would defend the mainstream nature in science at the time of the lobotomy and the leucotomy and scenarios like Goddard and Galton and others came up with in terms of what feeble-mindedness meant, and Lombroso's work on the born criminal and so forth. Those were accepted in mainstream science. And Moniz's winning of the Nobel Prize is only one example of that. But yes, but not one who had a lobotomy, so or a leucotomy. But so I understand that impulse. What I am saying, and again, this is mostly about the criminal law and how easily we seem to fall for what is being presented to us by psychology as the latest in its science at the time, right? And I think there are transcendent ways of thinking about that we normally apply to problems that are analytical that we don't when science presents us with findings like that. In terms of the vulnerability of psychology, again, this just comes, my conclusions about that are not original at all, but it does seem to me that it does look odd to us, of someone who's a newer student of psychology, that there is this ferocious idea, even to suggest that psychology might be something different from a science is taken to be impertinent, right? And yet it has been self-consciously different, for example, during the moral treatment period and so forth. And there have been historical movements that were very self-conscious, for example, by the early neurology in the late 19th and early 20th century, self-consciously to move psychology away from its more philosophical or a respect and kindness treatment mode, and toward being a real science, right? And I see some of that same drive. And what worries me about it, again, it makes perfect sense historically for psychology. I can understand that. What worries me about it is that I read these MRI studies, and so often, to use just the neuroscience example, the conclusions stated for them bear a very attenuated connection, let's say, to the actual data. And I'm talking about by the reporters, by the folks who write the studies. And really, I don't know that lawyers appreciate that, because I think we just accept the idea that if this is proclaimed as part of a scientific study, that means something that it doesn't necessarily mean. So.
Mark.
Okay.
Can I? If there is both the brain and the mind, and they are distinct, isn't that a form of dualism?
Well, as many of you in this room probably know, dualism is coming back among neuroscientists and among philosophers. I'm not back there with them. But your question is nonetheless a very, very good one. I think it is so mysterious how the mind is realized by the brain that I'm unwilling at present to take any stand. I think that what we know is you don't have a mind unless you have a brain. There are many different stories about how mental causation is possible that are not dualistic. I'm unwilling to take a stand in any of them, but it strikes me in terms of all the data we have and the best concepts we have The notion that our mental states play absolutely no role in causally accounting for our behavior justifies both common sense, logic, and the scientific evidence we have about it. Again, if we ever understand how the brain realizes the mind, there will be such a transformation of our biological understanding of ourselves and of basic physical processes in the world that I think all bets are off. Now, for those of you in the room who don't do the philosophy of this, there are a wide range of people out there. They're actually called Mysterians, who believe that solving this problem is beyond current human capacity. I'm agnostic. I don't know if it is, but what I do know is we ain't there yet or anywhere close yet. So I am always saying to people, calm down, slow down, don't be neuro-arrogant. We've learned a lot, but don't claim that we know so much more than we do, because essentially, at the most basic level, we don't know jack squat yet. We know a lot about the visual system. That we know a lot about, which is in many ways, as we're fond of saying in the trade, as you move from the outside in, we understand less and less. So we're better on the perceptual system, especially the visual system. Even the visual system can't be understood in isolation from the organism's interaction with the environment, but the notion that we have a deep understanding of mind-brain at present.
Thank you, and thank you all for coming. We are adjourned.
Thanks, Pete.